So Nick and I would like to keep today fairly informal. We'd like questions, sort of, I guess, instigate a bit of conversation around a lot of real topical areas at present. The three key areas that we're going to be talking on is firstly the temporary and proposed insolvency law reform and the impact of this obviously within your industry. We're going to be looking at some risk mitigation strategies, which I know Nick and I did a Zoom meeting with some of you a few months ago. We're going to pick that up again because it is now more than ever important as we sort of edge towards that potential tsunami, wave, trickle, whatever we're going to call it, of insolvency. So it's good to pick that back up. And then I'm going to hand over to Nick, and he's going to have the lapel, and he's going to run through some unfair preference case law that's played out in the courts recently, but also talk about what we're seeing anecdotally within, I guess, real life and within the industry. So we're firstly going to be looking at the misconceptions surrounding the temporary insolvency provisions. We're going to talk about working with these temporary insolvency provisions, what you can be doing. I've been speaking about this a lot recently. Some of you might be familiar, but it is worth touching upon because at the moment the law is changing pretty much every week. We will have a look at a high-level review of the small business reforms, the fundamentals around risk assessment, the most common areas of risk within the building industry, protection enforcement strategies, and then I said the unfair preferences. So please put your hand up, ask questions, let's have a discussion, particularly with the intimacy of this afternoon. If you do have any questions though after this afternoon, you've got our details, please give us a call. You will not be charged for a phone call, that's not how we operate. As Wayne said, we are friends of BICB. We are more than happy, even if you're not an existing client of ours, please pick up the phone and give us a call. We're happy to answer any questions. In March of this year, we did see a lot of law reform within the space, and what we're probably interested in most was the law reform with respect to the temporary insolvency provisions that came out in March. Interestingly, during this period, and I'm still finding it now, I did a presentation 2 weeks ago, there's a lot of misconception, misunderstanding around these temporary provisions, even though they've been in place since March. So I just want to have a quick show of hands, a couple of questions. Who here believes we can commence legal action against a debtor? Are we? Yep, great. Can we currently wind anyone up at the moment? Yep, great. Emma, you're cheating. You listened to me the other day. No, I'm kidding. Are guarantors currently liable are they personally liable at the moment? Yep, great. Excellent, good. So, the coronavirus economic response package omnibus that came into play in March is what introduced these temporary provisions. Now, you've probably heard it a lot, but it's worth running through these temporary provisions because, as I'm sure you're all aware, they were extended until the 31st of December of this year. The effect that they had was they increased the threshold from 2 to 20,000 for our statutory demands. They increased the threshold for bankruptcy notices from 5 to 20,000. They extended the time to comply for statutory demands from 21 days to 6 months, and the same for bankruptcy notices. And the other thing is that they provided the temporary relief for directors from personal liability whilst trading insolvent. So in and around, I think it was the 7th of October, we received, actually sorry, it was the 24th of September, we received notice that these temporary provisions that have been in play for 6 months were extended until the 31st of December. So what this did, I think, was generate a lot of conversation with a lot of people. A lot of the questions we were being asked is, okay, we've been holding for 6 months on a lot of potential winding up applications and bankruptcy notices. What can we do? There was a lot of misunderstanding as to what these temporary provisions were currently doing and what that meant moving forward. And I'm going to run through some alternate strategies in a moment with respect to these temporary provisions, but I think it's really important just to understand what misconceptions were out there and just, I guess, squash them. Firstly, the key thing is they're temporary at the moment, and I checked as of recent this morning. These temporary provisions are temporary. There has been no announcement at present as to whether they'll be extended. If I was betting, I would suggest that they won't be extended. We might see a slight variation to the normal timeframes and dollar value with respect to statutory demands and bankruptcy notices. I think we will see a change in there. I don't think, I could be wrong. But from what I'm hearing and the people that I'm talking to, I don't think we will go back to 21 days and the $2,000 and $5,000 limit. I think we'll see a variation on that, perhaps even say a 3-month time frame, something like that. That's my view, and it's just simply from sort of anecdotal conversations that I'm having. The other misconception, as I mentioned at the start, there's no current prohibition on the commencement of legal action, and something that I'll get to in a moment. If you are considering going legal, now may be your time, given what sort of changes are ahead outside of, or over the other side of Christmas in January. The other misconception was that legal action cannot be commenced against a guarantor. As we know, that obviously shut that out. At the moment, the moratorium only relates to insolvent trading with respect to directors within this time period. So there's that moratorium in place now at the moment if a director is trading that company whilst insolvent. And obviously, we can proceed with winding up applications. Had you issued a stat demand or a bankruptcy notice at the start of that 6-month period, you would be in that process right now. Interestingly, we know from our clients during that period, we had one client issue one statutory demand in that period because we didn't know what was going to happen. They thought, you know, everyone else pretty much was on hold. Lots of reasons, whether it's an internal decision, whether they're a financial institution, government body. We had one client. They then chose not to proceed with a winding up application. What we've got now is a lot of people coming to us and saying, well, what can we do in case it's extended a further 6 months? There are alternate solutions, and one in particular is relying on a different presumption with respect to whether a company is insolvent or not, and that is by issuing a writ or warrant in a court, having a sheriff or a bailiff, depending on the jurisdiction, go out and try and execute on that writ or warrant, and that writ or warrant coming back unsatisfied. There's a bit of criteria that needs to be met, but that can be then relied upon for a company to then move forward with an application to wind up. Similarly, we have similar provisions under the Bankruptcy Act where you can do the same if you have a bailiff or sheriff, attendant property, obviously try and recover to satisfy a judgment debt that's been obtained and it comes back unsatisfied. So there is the ability at the moment to move forward with that. Given a lot of our clients put this type of action on hold in the first 6 months, we are now moving through this other alternate strategy, and we've got bailiffs and sheriffs going out to try and have these writs returned and returned potentially unsatisfied. Obviously, if they're satisfied, that's great because you get paid. Otherwise, we've got something there to rely upon. It's important, I think, too, if your debt is insured and you need that active, or you need the company in liquidation, or you need that individual to be bankrupt, being able to move through some alternate strategy that's going to be a lot quicker than if you action a statutory demand now or a bankruptcy now and have to wait 6 months. Because the issue being, with the temporary provisions, any stat demands, any bankruptcy notices issued up until the 31st of December will still take that 6-month time frame. So there is that alternate strategy that I just want to put out there. The other thing is, though, we do have clients actually issuing statutory demands and bankruptcy notices because at the moment we still do not know what's on the other side of January, and we don't know what the government are going to do around these temporary provisions. So you do have some options. The one thing I will say, and even just chatting with some of you today about how business is going, and with all the stimulus that is floating around, there is plenty of cash out there at the moment because of the stimulus, because of the rent relief, because of businesses that have internally decided not to take recovery action, because the ATO hasn't been taking recovery action, all these types of things. So at the moment, take advantage of the cash now and do what you need to do because, again, my view only, I would say on the other side of January, potentially February, March, we're going to see a very different picture. So using these temporary provisions, I guess using the impact of what that has had on the industry to your advantage, you should be looking at taking action if you need right now, because potentially there may not be the cash on the other side. I feel like I'm speeding, it's the weather. Any questions on that? I appreciate this is all probably stuff you've heard before around the temporary provisions.
And what are you seeing in terms of how quickly new court actions are proceeding through the courts?
At the moment, all sort of courts are proceeding as per normal, as in, you know, the commencement of statement of claim, etc., moving through to judgment. There isn't too much of a hold-up. We did a few months ago have a bit of a delay in the various courts, but they seem to be going through. Again, it might be sometimes the Brisbane Magistrates Court is a bit delayed, or we have issues in the local court in Sydney, etc. But at the moment, things seem to be normal. There isn't too much of a delay. The only real delay has been experienced with respect to Victoria, with either having pre-hearing conferences set down or having sheriffs go and attend property because for obvious reasons. But at the moment, I'd say they're pretty much back to normal. The other thing with the court appearances, it's a sort of 50-50 again, depending on the jurisdiction, where you're either in person appearing or a lot of appearances are being done by phone or virtually. And additional steps for mediation as well being thrown into the mix, particularly again in Victoria, I think just because of trying to reduce that in-person appearance within the court. Okay. Well, I'll move on to the insolvency reforms to support small business. Who obviously has read about this, who has who understands what this reform is all about, who thinks it's a good idea, who's got some questions, who's cynical? No one?
I've read it, but I wouldn't say I understand.
Cynical? Yeah. So,
I understand the aim is to allow people to continue to trade, right? But
yeah.
what about our businesses?
Yeah.
Like we still also need to trade.
Yeah. Yeah, really good point. And I might actually, after this, Wayne, I made some submissions to this legislation on the, they were due on the 12th for a forum that I'm a part of, a credit forum in New South Wales, and I might actually share them because it was for myself and a couple of other members, and it picked up some really interesting points around what happens to you as within trade credit, and what impact does this have on you as you know, providing continual credit or continuing to trade with businesses that have problems. So I'll send them through to you, Wayne, and you can share them if you like or not, but yeah, interesting.
So these provisions for small business are for companies with a turnover, with debts of $1 million or less?
Yes. Yeah. So the proposal was released late September. We had some draft legislation on the 7th of October with more details to follow, with submissions being allowed by the public and various bodies, organisations, businesses, etc. by the 12th of October. The details are still fairly high level. The draft legislation requires regulations to be put into play, which I believe will be happening around the middle of November. But basically the premise being a new formal debt restructuring process, which sets out a new simplified liquidation path. And then there's complementary measures being introduced within the insolvency sector. The interesting thing, which I'm sure you're all aware of, which is probably a little bit topical, is that this legislation is due to commence on the 1st of January. So having read the draft legislation but not read the draft regulations, I'm a little bit concerned, but nonetheless, I'm sure we've got some good reading in those regulations. It is for corporations who have liabilities of $1 million or less. And the premise again being that a small business who fits within the criteria reaches out to a small business restructuring practitioner and says, I want to take up this regime. And they have 20 days to develop a plan with the small business restructuring practitioner. Yes?
I have a question on this, because how often do we see someone goes into external admin, yes, you're on 400,000, then they go up, and they keep going. So I get the theory of $1 million,
Yep.
but how often is that ever accurate, that the first amount is the right amount?
Yeah.
So what happens?
Well, good point, and that's actually a lot of the points that have been picked up in the submissions that I've read and that I was involved in. It's not actually clear yet how that's going to be all set out. That's what we're waiting on the regulations for, but that's a really good point because it may be that you think there's liabilities to a certain point, and then further on down the track there's more, but there's going to be more clarity in that space in the regulations. Sorry,
off topic. What constitutes a practitioner? Is that any chartered accountant?
no, good question. So more details to come in the regulations. And again, there's a lot of topic conversation, a lot of submissions made that it could potentially be an accountant, a chartered accountant, or there's a certain push for it to be a registered liquidator. It's not entirely clear at present, and depending on where you sit within the, I guess, the argument or the discussion point, you're going to have a different view as to whether it should be a registered liquidator or whether an accountant can be involved. There was even some submissions made by a particular association that it could be a lawyer. Pros and cons to all of it, because obviously we want people to have access to this, if it's to achieve, I guess, the ideals of why it's been put together. Questionable whether, if you're not a registered liquidator, you'll have the deep needed knowledge of insolvency and all, as you would through an administration or entering into a doc or something like that. So there's a bit of debate, I suppose, either way. And again, yet to be finalised in the regulations. So they put up a plan, and then there is 15 days for creditors to vote on the plan. And at the moment, it's 50% endorsed unsecured creditors. If 50% endorsed unsecured creditors approve the plan is in play. And then once the plan is in play, the business is to work with that practitioner to administer the plan. So if it is voted down, and this is again another contentious point that I've seen a lot of submissions on, if it's voted down, the company may go into voluntary administration or use a simplified liquidation process. And a lot of the discussion has been around, well, how is an administration going to be different to following the restructure process? So a little bit of question around there, and who's actually going to want to trade with a business that puts their hand up and says, I need to take up this process, and then for the plan to then be voted down, who's actually going to want to trade with that business? So then it's questionable as to whether a VA would be appropriate or whether it should be just using the simplified liquidation process. So there's a lot of bits and pieces, I think, that need to be worked through, which are probably currently being worked through, but that is one of the more contentious items that I've seen. The other thing is there's a transition period whereby if someone is to nominate an intention to take up this plan, there will be a transition period up until the 31st of March, where the business will need to give notice on an ASIC notice register that they intend on taking up this small business restructuring process. And this will then provide them with the similar provisions and moratoriums that are currently in place with respect to the temporary provisions, but there will be this transition period. So that's another thing to be aware of, is if you've got businesses who are giving notice that they're wanting to take up this process, well, that's an alarm bell for you too if you're continuing to trade. One good thing, I think, as creditors, is there has been some commentary. Again, this is pretty much all that it is at the present, to be detailed in the regulations, that there will be hopefully some restrictions around preferences and the ability to claw back payments that would ordinarily be considered a preference. It hasn't gone into too much detail, and it has been said that it will be included in the regulations, but it is good that preferences are finally getting some sort of recognition with respect to creditors and the impact this has. So there is hopefully something further on that, which will hopefully go towards, I guess, modifying the current regime as well. So fingers crossed we see a bit more there, and I'll let Nick talk to preferences once I step down. But yeah, at the moment, this is the proposal. As I said, we've got the draft legislation. I'll be interested to see how it changes if it changes from the submissions that are made from various organisations and bodies and the like. And then the regulations draft to be provided in November with a go live date in January. So I guess in our mind, what we can be doing is making sure that we're doing everything we can in the event that this does go live 1 January, and we've put ourselves in a spot that is the best spot to be dealing with businesses who may or may not consider taking up this restructuring process, because we don't want to be sort of in a spot in 1 January where we potentially have been trading with a business that puts a hand up within this and we don't sort of have all our ducks in a row.
So if we know that a customer is actually going to take advantage of this, what happens to the debt we already have? In a VA, that's kind of...
Yeah.
Will we have to park the debt and then
There is some moratoriums with respect to legal action against the company and against guarantors that have been set out as proposed, that there would be a moratorium placed in that. It doesn't necessarily wipe the debt, but there's moratoriums that have been set about being unable to take certain actions when someone has put their hand up and said, I want to take a part of that process, which is, again, another interesting point. And the other thing is there's some commentary around what happens if you've got, for example, a PIMSI and you want to go back and collect your goods. There hasn't been any, a PIMSI over something that you've supplied. There hasn't really been too much consideration given what happens with someone who has that ROT and that PIMSI right to collect the goods, because there is these very vague sort of laid out moratoriums that will be placed on you as the creditor to be able to take action. So that's another problem item for discussion. I think that will be fleshed out, hopefully, fingers crossed, once we see more with respect to the changes to the draft legislation. So I realise I'm talking very vaguely and I'm not deliberately doing it. There's just not a lot of actual meat that we know just yet around what it looks like, because it is in draft and because there was the opportunity to make submissions, and hopefully, fingers crossed, we do see some substantial changes with some stuff.
We see customers at the moment in building and it's all, they're going great guns, which you generally see that as we come into the Christmas period.
Yep.
Then come January 1, they're going to go, oh, got their money.
Yeah.
5 cents in the dollar for all
Yeah.
that stuff.
Yeah. And look, these are some real live risks, I suppose, and what we need to be considering right now with the strategies that we're putting in around all of that. But again, I think we'll have greater clarity come mid-November, and I'm happy to circulate some stuff to Wayne to circulate that when I've got greater clarity on actually giving you proper advice of what you should be doing with respect to what the legislation looks like. Yeah.
Can I ask your honest opinion on this? And can I also add, not just prejudice,
No.
can I also add that maybe we're just a bit tainted because in building and construction everything's strict and there's nothing left
Yep.
by the time they go. There is literally no money. So maybe this will work for other types of businesses, maybe just not ours. But what do you actually think about? I can't see it working, okay, honestly, because
Yeah.
I'm not going to supply.
Yeah.
I'm not going to continue. I can't see my insurer continuing.
Yeah.
I get my hands might be tied, but unless I get caught by some ipso facto clause or something that says my only, that I can't use a default clause or something, I can't see people supporting it unless they have to.
Yeah, there will be some provisions drafted within where there will be an element to not so much safe harbour, but continue on certain elements of the relationship, but obviously not having to necessarily provide new credit or new supply. What do I honestly think? At the moment, having looked through the draft legislation, read the handy fact sheet the government released, having wrote some submissions on it, I am concerned at current how it's drafted. I think ideally, I understand the idea. My concern is the things that haven't been fleshed out that impact the people that we generally act for, and that's the creditors and within the trade credit space. And I'm concerned particularly around what's happening with the ROTs, particularly just generally, you know, what a company actually needs to satisfy to be able to take up this process as well. That I don't think that's been ventilated enough, because it won't be simply as putting your hand up because you have debts under $1 million, or liabilities, I should say. They actually need to meet a certain criteria. So while it might at the moment look really nice, there might actually be businesses who can't in fact take that up because they don't meet the criteria. Again, I'm going to hold my view on it until I see what it actually looks like when we see the regulations, which will give greater clarity hopefully, and then the draft legislation is put in place, because it's pretty rushed. Like the legislation itself, when you read it, there's mistakes and different bits and pieces through it, so it is pretty rushed. Anyway, so that gives you cause for concern. But I do ideally understand why it's been put in place, but my concern is it realistic? And is it actually going to impact my clients negatively, because they will continue to supply to a company that, unbeknownst to what's actually going on, for them to then take up the process. So yeah, no definitive answer. I'll come back to you when the legislation's finalised. Yeah, so yeah, putting me on the spot, Maria. So this is why this next part is really important. Your fundamentals of risk assessment and mitigation. Obviously we had Patrick talk then about risk. Risk is something that we need to be focusing in on in our businesses to make sure at the moment we have all our ducks in the row because of what could happen in the future. Obviously when we're looking at our risk in our business, the questions we need to be asking ourselves is where does our risk sit? And it might be using tools like the tool Patrick just showed us, or it might be just looking at your debtors ledger, it might be just knowing who your customers are, that kind of thing, but you need to identify where that risk is. When you're looking at the risk, you need to know what your objective is, and that's quite, I think, obvious in mitigating that risk is obviously making sure that you're not exposed. And then the other thing you need to do is understand the actions and the strategies you can take to reduce or mitigate your risk. So there's been a lot of data floating around the number of companies that are currently trading whilst insolvent. I've heard different bits and pieces. I read something about 1,000 businesses trading whilst insolvent. There was other numbers with respect to there would have been at least, I think it was 35% of businesses now trading would have been wound up in the last 6 months. There's lots of information floating around. The key being, though, is that we know something is coming. To what magnitude, it is currently unclear. So what do we need to do is, firstly, is we need to identify how is that going to impact our business and where is the risk in our business and what can we do, I guess, to minimise any potential exposure with that risk in our business. So you guys have probably heard me talk about this a lot, but I'm going to talk about it because it is, I guess, it is so basic, but yet so common, where we see the areas of risk, and they don't seem to change, whether it's because of COVID-19 or whether it's just a regular year. The common areas of risk in business are fairly standard, I think, across the board. Firstly, when people fail to have an effective credit agreement and personal guarantee. Basic 101 credit management, but often is the case it's what lets us down and what we see in litigation not time and time again. Contractual documents, where they generally fail to consider the impact of coexisting agreements, which I think can sometimes be more fatal than just not having an effective credit agreement, because you might have contractual agreements in play where you think that you're set up in a really great spot, but inadvertently there's been something that's happened and they just fail to consider the interaction between each other. I mean, we were just having a conversation before around the battle of the forms and whose terms apply, that kind of thing. And it's a really big area. I couldn't tell you how many matters we have on foot at the moment that come down to this very issue. So it's something to consider. Another area is the inadequate security, and will be really, really important, particularly when we look at this new proposed small business restructuring and the impact of that on secured creditors. Having a look at what security you've got in place and taking adequate security, trading with your zombie business without a strategy, defective or incorrect PPS registrations. Another common area is a failure to identify or anticipate disputes, and then the failure to actually maximise your existing rights through having inadequate strategies. And that's something which can be quite costly, particularly when you have existing rights in place and you actually fail to use them at the right time. So looking at all of this, and a little exercise I did 2 weeks ago when I spoke on this very topic, because it's something I'm quite passionate about at the moment, was I asked everyone to identify who their top 5 most at-risk customers were and whether they could in fact actually identify who these customers were. And interestingly, it was about 50-50 with respect to the people who I spoke to after, when my team did, who could actually in fact identify who these top 5 most at-risk customers are. And I guess heading into the landscape and managing our customers in this current climate, this is the most important thing that we should be doing, whether it's your top 5, your top 10, etc. Just identifying exactly where that risk is and making sure you have appropriate strategies in place. So I guess who here could identify their top 5?
Are you talking about like a top, like as in how much money outstanding?
Well, just your most at risk. You know, the ones that are just on the edge that you're thinking, oh, what do I do here? Am I sending this through to a collection cycle? Am I sending this through legal? Like, they're really on risk. You're not sure whether you want to continue trading with them. You've got really concerns. You might be hearing some stories about what's going on. Perhaps you've run a couple of searches, that kind of thing. Like, do you actually know at the moment, if they fell over tomorrow, they would have the biggest impact on your business, like the top 5?
So we run it on risk category when we open an account, type of terms when we open them, and then our new collection system that we onboarded, we can tag customers.
Yep.
So we haven't been able to contact them for more than a week, 2 weeks. If they've said the business is closed, especially with COVID, that's been something where it's not necessarily a risk of cash flow, it's just a risk now because they're not there.
Yep. What about you, Emma? You put your hand up. You've got yours identified.
Yeah, pretty much. I just know just how long it takes to pay. That it pushes out further and further each
Yep.
month, and you sort of think, they're just getting slower every month, and it's not improving, never improves.
Yep.
Doesn't matter how long you give them, it just won't get better.
Yep. Yeah. I think, having that understanding of where that risk sits, and it might be a varied level of risk, or it might be risk for various reasons, but at least knowing where it is right now is one of the things that you should be doing right now, in case that risk becomes a bigger problem, at the other side of January. With the broad categories that I mentioned previously as to where we generally see risk, and we see this risk because it lands on our desk as a litigation file, or it's clients coming to us before it turns to litigation saying, I've got this problem with this customer, what do I do? And the 3 broad categories, if you break them down to everything that I've just mentioned, sit with contract, sit with security, and sit with strategy. The first thing, which is a really easy win, which everyone should be doing right now, I speak about it all the time, whether it's COVID or not, is making sure that your contractual documents are in place, in particular with your risk customers, but making sure your contractual documents are as good as they should be. So that might be simply having your credit agreement correct. Having a look at any sort of different contractual documents that you've entered into, whether, we were talking before about where you've signed, you've had a credit agreement signed, you've had a subcontract come in and they're trying to enforce their terms, or different purchase orders that have different terms, and then making sure that you know exactly where it stands, that in the event that you're left being owed money, or in the event of a liquidation, whatever the case is, you actually know what the contractual arrangement is between you and the customer, and you're comfortable in the documents that you have. A few months ago, we had a client who they were supplying security systems, and they had entered into a distribution agreement in November of last year. They'd been trading with this particular company for a while, entered into a distribution agreement, and it had the usual clauses around exclusive distribution, non-compete, etc. At the same time, they were actually trading with another business. They didn't have a written agreement in place, but they were trading with another business. So by that action in itself, they were in default of this distribution agreement. However, in then March of this year, they signed a second distribution agreement with this other business that they were trading with. What then happened was, why it sort of came across our radar, is the client came to us in May because they had tried to terminate that first distribution agreement because they'd entered into the second distribution agreement, and the first business obviously was alleging a range of things, that they were in breach of the contract, they had a claim for damages, all the like, because they had entered into a separate distribution agreement with somebody else that had exactly the same provisions, and they shouldn't have entered into that distribution agreement. Now, our client signed that second distribution. It was just part of process. They were caught up, they were busy. The impact of that agreement on the first agreement. And obviously then sent off the letter terminating it, again without considering the impact. The impact, and I guess the consequence of signing that second document could have been a $3.6 million consequence because of the claim for damages and the like that first business could be making with respect to the trade that was happening at that point in time. Fortunately, we did negotiate a commercial resolution where our client is continuing to trade out the period with that first business until the end of the year. But they were on risk for about 6 weeks, of a potential $3.6 million damages issue. So, but it came from something so, I guess, easy and just something commonplace that you would do within your role as the general manager executing this document, didn't even think about the pre-existing documents. And so something that could happen any day. So I share this because we were nervous for the client because of where they stood contractually and, you know, when the claim was being made against them, they had some real problems because of what happened. We were happy that we could negotiate the outcome, but also this kind of thing would happen, you know, every other day with people not thinking about what they're signing. So at the moment, I guess it's really, really important for you to be considering not just your credit agreement, what that looks like, but all those other agreements, all those purchase orders you're being sent, are you really comfortable with what that looks like? The next thing is your security. We talked about this when we had the virtual online meeting, I think May or June, whenever that was. But security now more than ever is important. It is always important, but now more than ever it's important. Particularly important with your most at-risk customers. If you don't already have security, think about taking security. If you have pre-existing charges in your credit agreement, think about registering a caveat. Maria and I had a conversation 2 months ago, I think it was, as to whether, you know, what she could be doing with respect to the extension of the temporary provisions, and we threw out the idea of, do we go ahead and register caveats on some people that we're concerned about? Because you've already got that pre-existing right provided your credit agreement is drafted in that way. So just taking one step further, registering that caveat is maybe something you might want to consider. The other thing is looking at whether you've got the ability to, I guess, negotiate a better position with respect to security. A particular client of ours who supplies fuel was having quite an amicable discussion regarding paying down a debt with one of their customers, and wanted a solution, I suppose, to be in a better spot to provide further security. And we were able to have a mortgage pulled together and registered on 2 properties of that guarantor. And it just provided that extra security for ongoing trade. So there was, I think, about $300,000 outstanding at that point in time. But to facilitate that ongoing trade, to give comfort, our client got that mortgage and we registered that on the property. So it is there as an option. And if you're having good communication with your customers, and particularly at the moment, I would be considering what else you can be doing with security. Of course, there's your PPS registration, may or may not be appropriate depending on what you supply, but again, something that you should be looking at. Whether you can be taking out an all-PAP, something like that, whether you can be, just double checking your security interests, looking at what you've got, whether you register your interest or not. Appreciate, again, depending on what you supply, it may or may not be relevant, but if PPS is something that you utilise, you should be utilising it right now. The other takeaway from things that we've noticed in the last few months with respect to PPS registrations, which again is not different due to COVID, but something really important to consider at the moment is if you are registering, make sure your registration is correct. It is just incredible how many times we see registrations, our verification statements that come through sort of at the tail end of a process where the client has inadvertently made a mistake and we haven't registered our security interest properly. Had one a few months ago where our client hadn't registered properly in Agri-Primsy. Could have cost them $320,000. Fortunately, it didn't, but their registration was defective. And I won't bore you with the details, but to show this great cow. But the key messaging being make sure your registration is correct and free from defect. The other third part, as I mentioned, broad category, is making sure you have the appropriate strategy in place. And that may not be a legal strategy. That might be a credit management strategy. Just know what you're going to do as a business and what your approach is when we are out the other side of January of what you're going to be doing with problem customers. Where, it might be, do you work with them? Do you put them on cash? Do you ask for more security? What do you do? What's your strategy? And actually have that in place now. So if we do even have a wave of insolvency or a wave of financial distress or whatever it looks like, you actually know what you're going to do when things turn bad, because they will turn bad. It's just to what level is that bad? Not stealing your words there, Patrick, about bad, very bad, whatever that was, but we need to have strategies in place. And that might be as simple, though, too, as having a look within your business and your customers as to where the potential disputes sit, and what you can be doing now using all these strategies to protect your business. In addition to that, is making sure that you look at your additional protection enforcement strategies. Again, we discussed this in the virtual, but just refreshing everyone on this is whether you need to be picking up additional guarantors at the moment. We have a client who is going through their whole customer base, all their credit agreements, doing property searches where they have personal guarantees provided and they know that that guarantor has property. They're actually looking at whether the co-owner of that property should also be providing a guarantee, even though they didn't get one in the first instance. They're assessing those that are on risk, so they're most risk customers, and they're looking at taking additional guarantors. So really, really basic stuff, but something that's extremely important right now with respect to mitigating and reducing your risk. The other thing is looking at documenting your payment arrangements, looking at, well, if you do have customers who are working with you right now and things are going well, can you be documenting your payment arrangements in a way that might rectify some issues that currently sit with your contractual documents, or might put you in a better position than you currently are with getting additional security. Plain and simple, it is basic, I know, but something that you should be thinking about with those conversations that you're having with your customers right now. So in the event of things not looking so great, you actually have certain arrangements in place that you can rely upon in the future, or you can potentially pick up an additional guarantor through a payment arrangement, something like that. And then on the other side of January, we see an insolvency, then you've picked up a guarantor that you may not have already had. The other point, how can I go back? Oh no, here we go, sorry. The other point which I mentioned just before as a strategy, but also a risk mitigation strategy at the present, because of the cash that is floating around, don't be afraid of litigation, don't be afraid of the fight, because at the moment with the proceedings that we are commencing, a lot of them are actually resolving by way of a settlement or by way of a payment arrangement, or defendants are ringing us and saying, look, I want to pay, but rather than paying it immediately, I need 3 months. Because people have extra cash they may not ordinarily had, but taking that step to commence litigation is actually getting results. So don't be afraid of it, but also use it wisely and use it in the appropriate time, because it might be a litigation strategy that is more appropriate. I guess the last point that I'd like to say before handing over to Nick around this risk and I guess utilising risk strategies at the moment is to assess your risk early and to mitigate your risk early by obviously running your due diligence in the processes that you have in place, looking at the procedures and moving on it quickly. And even if you just identify it early and you have a plan in place, you may not need to move on that plan until event of worst case scenario or in an event of default or something like that. But if you can identify it and assess it and know what it looks like, you will be able to mitigate your risk in a better fashion. Anyway, I'll hand over to Nick now. We need to do the mic swap.
Well, thanks, Anna. As mentioned, what I'm going to be discussing is unfair preferences and sort of just looking at where things sit at the moment, having a look at the COVID landscape, where things potentially look like they're going around unfair preferences. So sort of the current trends that we're seeing at the moment is certainly an upturn in preference claims. That may be as a result of the limited work that insolvency practitioners have on at the moment. So there's limited appointments. They've got to generate revenue. They go through their books and figure out, okay, this is a claim we might not have chased, or we might want to have a look at again and shoot out a demand and see if we can get anything out of this one to try and get some funds in the door. That's certainly, I think, potentially one of the reasons that we're seeing an upturn, but generally in the last couple of years we've seen an uptick in preference demands anyway, just because they're really the best way for insolvency practitioners to make some sort of a recovery, with insolvent trading claims, uncommercial transactions being pretty hard to pursue and usually having pretty limited prospects of recovery. The zombie ones is a similar one. Again, I think Emma, you were on the the end of one of these just recently. When a liquidator is appointed, they've got 3 years from the date of their appointment to pursue any preference claim. We're seeing a lot where there's nothing being done by the liquidator for about 2.5 years. Gets to that point in time and they go, okay, we need to do something about this now. The demands go out, see what they can get in, and proceedings are being commenced the day before the end of the 3-year limitation period. I had one recently where we had 5 or 6 creditors involved in a single proceeding that was commenced a couple of days before the end of the limitation period. They hadn't received a demand from the liquidator until about 3 months before the expiration of that period. So that's certainly a significant trend that we're seeing, and uncommercial quantums as well, so just small amounts being pursued, again likely because prospects of recovery for insolvency practitioners are limited elsewhere. So get the demands out, see what they can get in, and utilisation of what's called a mothership proceeding has also been, I'm seeing a lot more of that. So that's in the same proceeding, so instead of going against just one of them, filing a claim in a separate proceeding for each one, they all get lumped into the same proceeding. Liquidator pays one filing fee, so they save a bit of cash there, and it all goes ahead as one proceeding up until the point in time where they establish insolvency, which is the only common issue, and then everything splits off. It's generally a lot more expensive for creditors because you have to deal with some issues that you just might not want to have to deal with. You might not want to participate in the question of whether the company was insolvent or not, but you're dragged along through the process and have to incur costs along the way, just because the liquidator gets to save a bit by going through that sort of a process. So that's what we're seeing at the moment. Getting a lot of questions around what things potentially look like post-COVID when we're seeing a lot more insolvency appointments, and usually the common question is, is any payment received during this period going to be an unfair preference? And the answer is obviously no. There's no automatic presumption of insolvency during the period, so because someone's on JobKeeper or anything like that, there's no presumption that they are insolvent. So the same principles still apply in respect of a preference claim. So the liquidator needs to prove that the company was insolvent at the time of the payment. Payments made out of company funds, and the creditor received a preference in receiving that payment. So it's not going to be the case that just because we're going through this period of unprecedented change, that every payment that was made is going to be an unfair preference. There's been a lot of submissions put forward to try to get a similar moratorium to the insolvent trading in respect of preference claims. I think because there is that concern that once we do start seeing appointments coming through, there's going to be a sea of claims. So nothing has been announced or nothing has been passed in that space, but it's certainly one where there's a lot of people pushing for a similar type of a thing, because of the risk then really just being passed on to creditors again. You've had your directors who have got off during the period, so we'll put everything back on the creditors. Similar again, liquidator is appointed, where are they going to get funds from if there's nothing in the job when they're appointed? So they're going to need avenues to pursue these types of claims to generate essentially income for themselves a lot of the time. And you still have your defences available. So similarly, again, just because someone says to you that they're on JobKeeper or they've got some sort of a downturn in revenue, there's no automatic assumption that they're insolvent, and you won't be able to rely on a good faith defence in the circumstances. So that's just the thing to remember, I think, really, is that nothing's significantly going to change, and you would never really put yourself in a situation where you're potentially knocking back payments when you're concerned about a potential preference claim down the track. You always get the funds in, and then you can deal with it later, and you can always negotiate a better outcome with the liquidator than you would just saying, oh, we're not going to take it because there's preference risk around it. Anna touched on the potential carve-out in the simplified liquidation process in respect of unfair preferences, and all that we know about it at the moment is that there's a mention in the legislation that the regulations can make certain circumstances where liquidators can't chase preferences during that simplified liquidation process, and because we don't have the regulations, we don't know what they are. And in the explanatory memorandum, the examples that are given is just potentially a limit on the period, so it might not be, you can go back 6 months from the point of liquidation, it might be a shorter period to, let's say, 3 months. Or there might be a limitation on value, which I think is going to be probably a difficult one to really quantify exactly what sort of a value you'd place on that. So again, no idea what's going to happen there. We're just going to have to wait and see and keep an eye on exactly where that ultimately gets to. So where does that lead us in terms of going through and navigating this period, and really what you should be doing? And as set out already, get your house in order at the outset. If you've got things in place like security from the outset, you've potentially got something then to immediately push back on the liquidator to say, well, I've got security in place, so it's not an unfair preference claim because they only apply in respect of payments received for an unsecured debt. So you can say, well, I'm secured. It's up for the liquidator then to go and prove that your security has no value, but a lot of them don't want to spend the time and do the work to actually do that. So getting things right at the outset and getting a charge over all their property, or you've got your ROT, is really important. Taking additional security where you can. If you do a review and you're looking at the strategies, as Anna mentioned, that you can put in place, you go through your documents, something's wrong on there, or you don't have particular security in your documents because it might have been an older agreement that you were using at the time. Looking then, if you're entering into some sort of an arrangement, is what additional security can you take? Can you take a charge? Can you register then an all-PAP over the company's property? Just again to try and reduce the risk there. Always being conscious of what's put in writing. It's not something that will always save you, but it certainly makes it easier in the early stages of dealing with a preference claim. If you don't get in the demand from the liquidator, here is all the correspondence that you exchange with the company about what poor a financial situation they are in. So having a think about what you and your staff members are potentially saying in correspondence certainly helps with just trying to deflect at the outset dealing with these sorts of claims. I can remember one example I had where a client asked in an email to the company debtor, are you insolvent because you can't pay this? We get the preference demand from the liquidator. They just point to this one bit of correspondence. Your good faith defence is pretty much shot. So that one certainly makes it a little bit more difficult. So just having an understanding of what to put in writing is really important. Whether you do COD terms, that's just part of generally managing your risk, and I need to switch them over. That potentially does have impacts on your good faith defence if you're receiving payments then subsequent to when you put them on COD. So you're getting your COD payments, but then you're still getting payments in to pay down an existing debt. That can have an impact on that, but still it's about trying to reduce your total overall risk. So looking at that. And the last one is third-party arrangements, and I'll elaborate on this a little bit more because there was a decision in the Victorian Supreme Court Court of Appeal recently, and some of you may recall this was a decision that I spoke about last year in this seminar when it was coming straight out of the Victorian Supreme Court. So this is the next iteration of it from when it went on appeal. So these are the background facts. I won't go through each one, but in short, there was a dispute between these two companies. So Mad Brothers was the supplier or creditor. Eliana Construction was the debtor. They supplied earth moving services to Eliana. A lot of things followed, which in short is that they didn't get paid and they needed to take steps such as issuing a statutory demand to try and recover. There was a couple of proceedings that were commenced. There was one in VCAT that was commenced, and then there was subsequently a winding up application, and pretty much they got to the 11th hour of the winding up application and they've entered into an agreement with them to receive a settlement sum to pay it out. The arrangement between those parties were essentially that Rock Development, which was a related entity of Eliana, was to get finance to then pay this amount to Mad Brothers. That all went through, so they got the finance, they paid them out, but they eventually went into voluntary administration and liquidation. So the key issues were looking really at whether the payment that was made on behalf of Eliana from their third-party related entity was a payment that was made out of company funds, because that's a key element of an unfair preference claim. It needs to come out of company funds. And there was also a question around whether the creditor had a good faith defence. So I think when I was here on the last occasion, we were down to the single judge appeal, and single judge decided it wasn't a payment that was made out of company funds, but they also decided that they probably would have got up on the good faith defence, and it then went to the Court of Appeal. Court of Appeal agreed on the third party point but disagreed on the good faith point. The key to the decision in the Court of Appeal was looking at whether there was assets that were being diminished from the company's funds. And so the distinction that was made, and it's easier to look at it from this perspective, was there was a dispute as to whether there was a debtor-creditor relationship between Rock Developments and Eliana. And there was an argument that was made that Rock Developments, which would be here, owed money to Eliana. But they couldn't establish that there was any money that was owed. So the court found that there was no preference on the basis that there was no money owed from the third party to the debtor. The key difference being that if you have this situation, on the debtor's books, you've got an asset in a receivable. On that one, you don't. All that you'll have is that the third party then potentially becomes the creditor, and it's just a switching out really of who's owed the money. There's no asset that actually goes down in the company's books. So that's the key distinction there, and it's not always a situation that's going to arise, but it's not uncommon that we deal with groups of entities where one entity will be paying on behalf of others. So it's important to look at what are the asset positions and the trading positions between those interrelated entities. And when you're potentially negotiating arrangements with your customers, is looking at whether something like this is an option. If you can say, well, can we get it from a third party, and then what's the relationship between the third party and the debtor? It's not always going to be applicable, but it's certainly something that we look at pretty critically now is, where are the funds coming from? Show us on the company's bank statements that it's coming out of their account. If it's not coming out of their account, it's coming out of a third party's. What's the relationship there? That's really it on preferences. Was there any questions around just preferences generally, or what it's potentially going to look like?
It will be very interesting.
Mm.
It will be very interesting the way the legislation coming month. funds. And there is some degree of speculation around whether they'll actually get it through. And so I believe that they may be looking at a contingency period up to the 31st of March.
Yeah, and the important thing with that is it's only applicable to that simplified liquidation process. So it's not going to be across the board, it's only in that circumstance. And I think, as we've already said, the potential uptake and use of that particular process may be quite limited. So while there might be a small win for creditors in a sense where they've got this carve out where companies are going to use this simplified liquidation process, it doesn't change anything in respect of anything else. So it may only be a very, very small portion, and they may even, really being the ones, what they're going to potentially carve out are probably the ones that are usually easier to defend if they're, small quantums or something like that. Liquidators might not be chasing them. They're probably going to just really be the ones that are, very clear. They might be very close to when the company goes under, so it's a lot clearer. But it's probably going to be quite limited in application, and we're not going to see a fair bit of it. But we'll wait and see what happens there with the legislation and when it actually all goes through.
Nick, is there a way to retrospectively mitigate your risk of a preference clawback? So what we see at the moment is a lot of liquidators are very quiet on work, and we've certainly heard of ones who are going back and dusting off all their old files, going, gee, I wonder if there's a preference in here somewhere that we haven't looked at hard enough yet. Is there a way to sort of, after the fact, protect yourself?
I think other than getting good advice on it, probably not. If they're gonna chase them, they're gonna chase them. There's nothing you can ever do to completely knock out a preference claim. If they've looked at it and they've seen funds coming out of the bank account 6 months prior to liquidation and they want to pursue it, they can pursue it. You might have the best defences in the world, but you can still get dragged through the process. So usually, if you want to deal with it after the fact, the best things to do would be proactive about it. So if you get a demand, deal with it. Don't just put your head in the sand and just hope it goes away, because what we're seeing at the moment is they're not. And then if it's going to that next level, is getting the right advice to be able to appropriately respond and try and knock it out as quickly as possible. And if there is risk on it, trying to enter into terms of settlement at an earlier stage to resolve it for really the smallest amount you possibly can if there is some sort of a risk, because they're generally, a liquidator will be a lot more inclined to settle it on pretty favourable terms if they don't have to run off and commence proceedings and incur costs of getting like insolvency reports done and all of that kind of a thing. So just dealing with it, being proactive and getting advice early if you're potentially on risk is the best way to deal with it sort of retrospectively. Okay, so wrapping up.
You mentioned about, full out asking people if they're insolvent. I'm fighting a preferential claim at the moment where they had a $300,000 job and only had a 100k credit limit, and they were particularly bad payers. And I said, I'm sorry, I'm not willing to increase your limit due to your poor payment history.
Yep.
We would like a bank guarantee or a deposit which we'll hold against the work. So we got given a $300,000 bank guarantee, which we held. We did the job, we got paid, gave them back their guarantee,
Yep.
and now we're getting a preferential because they're trying to say that we knew that they were insolvent because we asked for bank guarantee.
Yeah. Usually with these type of ones, and we commonly see it sort of generally with any sort of good credit policy, is that's used against the creditor to try to say that they had some sort of knowledge of insolvency. So things exactly like that, where you might say, we're not giving you a limit increase, or we're not extending further to you, or you need to make a payment to get back under your credit limit is usually a common one. Liquidators just look at it in isolation and go, well, the reason you weren't supplying is because you must have known. And it's just, a lot of the time it's just trying to work with the liquidator and get them to actually appreciate what the commercial situation is and what the commercial realities are, rather than looking at particular things in isolation. And like the other one we see a lot is just looking at their, days overdue. They've paid outside terms that you must have known, which is just nonsense, because I don't know of any of you in the room who pays you inside your terms.
Which means that as a defence.
So-
We've got, 5 years worth of history where they've never paid us on time, which is why we weren't going to increase their limit.
Yeah,
And also the fact that the bank gave them a bank guarantee for the 300 grand, because that means that the bank must have known they're insolvent too, so why would the bank give them that?
yeah,
So that's been my whole defence, and
Yeah.
we're still waiting to get
yeah.
that back.
It's certainly one of the difficulties that we
There's no
deal with a lot.
obvious letters that we can say.
No, and because every liquidator that you deal with is different, some will understand it, others just look at those sorts of things and go, well, that must be it, and you must have known. So it's using what you've got and the information that you've got available to really put the spin on it of what it actually is, and getting them to appreciate that, which it can be difficult at times, and it can usually result in you incurring significant costs to have to go through the process of establishing that, potentially up to the point of going through court proceedings where a court will actually look at it and they look at the commercial realities of the situation in the context of your good faith defence. But if you've got a liquidator on the other side who doesn't want to have a bar of it, it certainly does make it difficult, and if their solicitors are similarly minded. So that's sort of one of those situations as well where you just can't prevent these types of claims being made and pursued to whatever extent, no matter how good your defence is. If you can't get them on side with it, you just have to go through the process and use what you've got to be able to push them to the point where they either capitulate or you can resolve it on some sort of commercial terms. Is there any other questions on references? No? I think, I suppose in the interest of time, we can just quickly rip through the practical takeaways. So, first one being the temporary provisions are only temporary. Potentially going to see the end of them at the end of the year. I think the government's banking on their new reforms being the saviour, and we won't need the temporary provisions anymore. So, as Anna said, we might see a modified version of them. We might see no change at all. We just don't know yet. You can still commence legal action, so take action while you can. There's nothing that can prevent you there, and there's no changes that have been put in place that can stop you from really generally doing what you've always been able to do and enforce any sort of legal rights that you've got. Using alternate strategies where you can, whether it be the alternate strategies around the winding up process, or just looking at other strategies outside the legal sphere to be able to boost your recovery where you can't use those particular processes that might put the most pressure on your debtors if you're at that point. Touching on the small business reforms again is, I think, just keeping yourself educated with what's going on there and what the changes are, and if there is sort of anything significant that's going to come out of that, what changes do you need to put in place internally, but just keeping across it as we slowly get towards the start of the year where they're supposed to kick in. So looking at the risks of your business, things like, again, getting your documents in order, looking at your top 5 customers, who they are, or 10 or whatever it is. What are the most common things that can really impact your business. So Anna mentioned contract security, strategy. Review your documents, get everything right from the start. It makes it a lot easier than when you get down the track and you've got to deal with Anna or I telling you that something's gone wrong along the journey, and it's going to potentially cost a lot of money to resolve it. So getting things right at the outset, whether it's your credit agreement, getting your personal guarantee in place, looking at that point in time as well, if you've got significant accounts, what other things can you put in place if you need additional security, whether it might be a mortgage or something like that. Who are your top 5? Again, get your house in order. It's a bit of a common theme across these. What are your security arrangements presently? So review your documents. Is what is in your documents what you think is in there? Or are you just proceeding on the assumption that it must be all correct and you've got the right security in there that you think you've got, and if you don't, fix it. As I said, take a mortgage if you can, if there's circumstances where you've got a customer coming to you maybe and asking for a significant limit increase that you might not ordinarily look at. Bank guarantee as well, looking at those types of arrangements if you're not willing to go that extra step. Register your interests, make sure they're right. Go through the process, and there's a lot of providers out there who can do reviews of your security interests to make sure that they actually reflect what you're entitled to. If you're entering into arrangements, get an additional guarantor if you need to look at something like that, or if there's additional property, look at that type of thing. Document your payment arrangements. One of the more common issues that we come across is a situation where there's some sort of arrangement in place, a couple of months down track, that falls over, and then all of a sudden the debtor wants to dispute liability for any amount. And you go back to the client and say, well, what was the arrangement that was in place? What were the terms that it was put on? It was just, oh no, they were just going to pay us X amount. So having those things documented with an acknowledgement or something in there saying they agree to pay this amount, you know, they don't have any other claim, or they release in respect of any other claim that they might have against you, certainly assists down the track. And I think we're going to be seeing a lot more disputes in the future when the temporary provisions end and there's prospects that companies are going to be wound up pretty quickly. That's when we see disputes starting to arise. So don't ignore them, deal with them early, because it becomes very costly to deal with them down the track. That being said, don't be afraid of litigation. If you need to commence proceedings and you want to take action, push things along early. As we said, we're seeing that there's a fair bit of cash out there at the moment, so really putting your hand up and being the first one in the queue rather than sitting back and just waiting and seeing what happens, and you ultimately end up with nothing. So pushing things through and taking action where you can and putting those strategies in place to reduce your risk and exposure. So that's it for us. Was there any other questions? I don't think we're right on time.